Remember how I said Alaska is a very strict state when it comes to alcohol charges or alcohol laws? Apparently the way around that is if you work for any sort of law enforcement or affiliated in any way. I've seen a case where a 19-year-old girl, the daughter of a well-known attorney, got a slap on the wrist for killing a man while drunk driving. Meanwhile, we have cases like the ones I told you about before, where there was a man standing outside the bar waiting for his DD. He had not gotten in his car at all, and he still got arrested for a DUI. Or the one I posted yesterday, I think it was, where the girl passed her field sobriety test up until they told her to walk, and she physically could not walk without crutches. So they failed her because of that. She blew a .006. Legal limit is .08. And then today, I open the news and I see this. State decides not to prosecute former APD officer charged with driving impaired off duty. How interesting. I have seen laws change because legislators' kids got in trouble with the cops. I have seen the court put out two different versions of a case. The public version makes the state trooper sound like the nicest person ever. And the real one that is confidential says what a shitbag he was. And then there's this. Let me just read it for you in case you're not at the same level I am right now. So in early January, a police officer was driving in his patrol car. He was invited to an on-base event, it says, and when he arrived there, he was drunk. So Mans drove to a military party in his cop car while drunk. It is important to note he did remain employed by the Anchorage Police Department while they were investigating. By mid-January, it said he had left the department, but nobody is sure if he quit or if he was fired. Based on events and based on what I have personally experienced, I'm gonna guess he was told to quit, or you can never work for us again. The state decided not to prosecute him because, quote, the state went through the evidence and determined there's not enough proof. Well, that's funny, because you can charge people that are standing outside a bar saying intent to drive when there is physical evidence that they did not get anywhere near their car, but go off. Then they lost that evidence